Okay, we good?
Yes, sir.
Okay, we'd like to call to order the Thursday, August 24th, 2025 meeting of the City of New Bern's Board of Adjustment. And first, we'd like a roll call, please.
Yes, sir, Mr. Chairman. Board Member Sandra Gray.
Here.
Vice Chairman Eric Thompson.
Here.
Board Member Kathleen Marty.
Here.
Chairman Tim Tabak.
Here.
Board Member Trey Ferguson, and let the record show he is absent. Board Member Leslie Allen.
Here.
Board Member Ryan Lanchey, and let the record show he is absent. Board Member Ashley Howe.
Here.
Board Member Barbara Sampson.
Here.
And Mr. Chairman, we do have a quorum.
Yeah, thank you. This time, we'd like to do the Pledge of Allegiance, please. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So tonight we've got an appellate hearing, and I've got some remarks to make, and I'm going to read from a sheet. And I've also asked Jamie to step in a time or two as we go through this so we can make sure that everybody is aware of the process. And, you know, we don't have a big crowd, but still, please try to respect everybody and cell phones off and keep conversation to minimum so we can all hear. So this is a quasi-judicial hearing which proceeds very similar to a court hearing. We ask that you respect everyone in attendance and do not engage in disorderly outbursts or any disruption. If this takes place, you may be asked to leave or be escorted out by an officer. We will call the speakers up to the podium to speak because these proceedings are being recorded. This evening hearing is an appeal of a decision by the New Bern Historic Preservation Commission to approve or deny a certificate of appropriateness. This appeal is in the nature of, please help me.
Certiorari.
Yeah, thank you. Meeting the hearing is a review of the HPC's decision based on the record of case. The appellate has filed an appeal of a decision by the HPC approving the partial demolition and redevelopment of the subject property located at 403 East Front Street. This subject property is owned by Craven County. Craven County has filed a motion to dismiss the appeal for lack of standing. The first portion of the hearing will be focused on the issue of standing. Is there anything else to add, Jamie?
Not that I can think of at this moment, I'm sorry.
Okay, thank you. So next we'd like to swear in all the presenters. So everybody who will speak, please stand up. And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yeah, thank you. So prior to starting with the appellate hearing, we are going to discuss two decisions we made at the last meeting. The first one in reference to Settineri Commercial, and we do have the documents here of what we approved. Is there any discussion in reference to those documents?
No. Done.
Do we have a motion to accept as written?
Are we accepting both of them simultaneously?
Just one at a time.
One at a time.
And I think the first one actually had a condition,
Yes.
and the condition is listed. So no, just one at a time. So the first one is just Settineri Commercial. If everybody has a minute to read back through, if they haven't already.
Mr. Chairman, I move that we accept the special use permit 003013-2025 with condition as approved by the board at our last meeting.
So we have a motion. Do we have a second?
I second that.
So we have a motion and a second. All in favor?
Aye.
Any opposed? The motion carries. So the second one is in reference to the Craven County Nature Park, also at the last meeting that we discussed, and we approved. But if we have a minute, if you all haven't already, please look through and make sure that everything is in accordance with what we agreed upon at the last meeting.
Mr. Chairman, I move that we vote to approve the Craven County Nature Park SUP 003026-2025 as documented in our package.
So we have a motion. Do we have a second?
A second.
Okay, we have a motion and a second. Any discussion? All in favor?
Aye.
Any opposed? The motion carried. So in reference to our next appeal application, this is 403 East Front Street, BRDADJ-003074-2025. Kendrick, are you able to come forward and make
Yes,
a
sir.
presentation?
Sure.
Yeah, thank you.
Good evening, Mr. Chairman, and to the board, and thank you, Mr. Chairman, for also reading that out. As stated, this is the appeal for the 403 East Front Street, and this is specific to the determination of standing. The request summary here, the appellant party is Mr. Matthew Halton, and the owner is Craven County. The parcel identification number is 8-002-B, as in boy, -179. And the zoning district here is Commercial 2, or C-2. And currently, just for the board's reference, this is General Statute 160D-1402. Essentially, specific to subsection C, this is the dictation of standing, and essentially how the state's legislature looks at said standing. It is more or less the reference point for you all, just to review. Wasn't going to go into deep detail, but I can refer back to this at any time that the board wants to reference it or look at it once, further in terms of just trying to process the information. And if the board doesn't have any additional questions, I know there's not a whole lot to go through as far as for the PowerPoint, but I'll accept questions at this time if necessary pertaining to the item.
Do we have any questions for Kendra? We good? Okay, yeah, thank you. Yes, so since Craven County filed the motion to dismiss, we'll hear from Craven County first. And I'm assuming, Mr. Grady, you come forward. And please state name and address and representation.
Yes, sir, Mr. Chairman, members of the board. My name is Harry Grady. I am the county attorney for Craven County. My address is 2203 Hidden Harbor Drive here in the city, 28562. Mr. Chairman and members of the board, the issue before the board this evening is standing, and it's the standing of the appellant to bring the appeal that's at issue this evening. Briefly on the history of the case, at the February meeting of the Historic Preservation Commission, a certificate of appropriateness was approved in favor of Craven County for the demolition of the Sudan Shriners building, which is literally around the corner and down a block. The appellant, Mr. Houghton, timely filed his appeal, and that brings us here this evening. Not long after he filed his appeal on behalf of Craven County, I filed a motion to dismiss, again based on standing, and again based specifically on the statute that's still projected in front of you this evening, 160D-1402C, and it's actually subsection 2. An appeal may be brought by any other person who will suffer special damages as the result of the decision being appealed, i.e. as a result of the COA as issued by the HPC in February. Standing as a general matter is one of the fundamental principles of our judicial system. It is the legal right of a person or party to participate in a contested case. You've got to have some interest in the subject matter. You can't be a stranger to the case, as the law says. You have to have some connection to the substance of the case, the facts, the parties that are already involved. You see standing throughout the legal system. It is in hundreds, if not thousands, of cases, and the standards for standing in any particular case or in any particular subject matter varies. It's not the same standard from a land use case as it might be for a personal injury case, as it might be for a breach of contract case. We are fortunate in North Carolina that the appellate courts of this state have set out the rules of the road very quickly, very clearly. We know what is required for standing in a land use case in this jurisdiction. You'll hear tonight about cases involving the Fair Debt Collection Practices Act and the Fair Credit Reporting Act and elections law. Those cases are irrelevant because they deal with standing in different contexts. We're going to talk about standing in the land use context this evening. Craven County's argument is based really on two factors. The first is that the appellant has admitted that he does not have standing. There was an email that we obtained through a public records request that was attached both to the motion that we filed on behalf of Craven County, and it was also attached to the memorandum of law that we filed earlier in the week. And in that email, the appellant stated to Alderman Rick Krill, as a member without standing during the hearing, I was unable to provide opinion or testimony during the meeting. Mr. Chairman and members of the board, in the land use context, you either have standing or you don't. You don't have standing for one part of the proceeding and no standing for the next part. If you have standing for the quasi-judicial proceeding before the HPC, you have standing tonight. So by admitting lack of standing before the HPC, the appellant has admitted that he does not have standing this evening. The argument could very well end there. It's pretty direct and pretty straightforward. But in the event the board would like to delve into the substance of standing, let's pretend that the admission didn't occur. Would the appellant still have standing? And the answer is a pretty resounding and clear no, because of the factors that the North Carolina appellate courts have set forth. And there are two primary factors at issue this evening. The cases have been cited amply in the memorandum of law that I provided earlier in the week. But the first factor is proximity to the subject matter of the permit, i.e., do you own property adjacent to the county's property or near the county's property or in the immediate vicinity? If you do, you've met the first factor of standing. I submit to you in this case that based on the base of the applicant's appeal, he lives in Riverside, which according to MapQuest, at least on Tuesday, was 1.2 miles away from the county's property. It is impossible for the appellant to establish standing based on the proximity factor as a matter of geography. The cases talk about adjacent properties, properties across the street, properties in the general vicinity, but someone that lives or owns property over a mile away from the subject matter of the permit simply cannot establish standing as a matter of geography. If there's another factor at play here that really goes additionally to the heart of standing, and that would be special damages. And the concept is captured in the statute 160D 1402C C2, that's a mouthful even for a lawyer. So special damages are defined by the courts of this state as a economic loss to specific real estate. Let me say that again, an economic loss to specific real estate. When you think about it in conjunction with the proximity argument, you've got to own property near the subject matter of the permit, and you've got to be at risk of suffering a loss of value to that property in order to demonstrate standing. And it cannot be what the law calls speculative. You've got to have some pretty heavy-duty expert testimony that, Mrs. Smith's property is worth $100,000. If you allow this permit to be issued, her property is going to be worth $75,000. And that helps you hit the special damages benchmark. Even if you can establish those types of damages, you have to prove what I call one additional sub-factor, is some physical cause, if you will, of those damages. And the cases talk about stormwater runoff, increased traffic, blocking of view, blocking of sunlight. So you have to have these factors that together, one, you're close to the subject matter of the permit. Two, your property is going to be economically harmed. And three, it really has to be from a physical result, if you will, of whatever the particular permit is. Mr. Chairman and Board, we would submit in the appeal this evening that it is impossible for the appellant to demonstrate standing. One, he's admitted that he doesn't have standing. Two, his property interest is nowhere near the Shriner's property. It's at least a mile away. And three, in none of the materials that have been submitted to you relative to this appeal have you seen any allegation of damage to the appellant's real estate over in Riverside. At best, you see some general allegations that if the building is allowed to be demolished, that it will in some manner harm the historical fabric of the community. And the cases have been clear that general community damage, i.e. the community won't be the same. We'll have more traffic in the community. Those don't cut it. Your damages have to be tied specifically to the particular property that you own. So I will conclude there. Council, if you have any questions for me, or if it's appropriate, if the board has any questions, I'm glad to stay here all night and talk about these cases, but my guess is that help us lose if we did that. So,
well, before we go any further, I think it's important, just for clarity's sake, just to illustrate just a little bit of some of the concepts that Mr. Grady has shared. Mr. Grady's talked about cases, he's talked about statutes, and I think some of the materials that you all have received in advance of the hearing talk about all these different bodies of law. And I know one of the things that you're going to grapple with this evening is what rules apply. So when we're thinking about what laws supersede the other, I think it's important to go back to high school civics class. So we have three branches of government in the United States. We've got the legislative, we've got the judicial, we've got the executive. The legislature writes the laws. They enact the laws. The judiciary interprets those laws. So when we're thinking about and we're analyzing how do we apply statutes and cases and how do we read them together, it's important to bear those roles in mind. That the legislature in North Carolina, called the General Assembly, will enact a law like a statute that Mr. Grady has referenced. And thereafter, if there is confusion about what the words in the statute mean, how broad is it, how narrow is this what we really intended, those challenges go to our appellate courts in this state. And the appellate courts in the state of North Carolina will render decisions that help us interpret what the statute means. Okay? And I emphasize the North Carolina connection because land use law in North Carolina is a state-specific issue. The federal courts generally do not deal with land use issues like the ones that are before you. So as Mr. Grady indicated, back in February 26th of this year, the Historic Preservation Commission conducted a hearing. They are a quasi-judicial board. I say that because it's legally significant. They conducted a quasi-judicial hearing. They came to a decision based on the information that they were provided, which some of that was included in your package. Appeals of quasi-judicial decisions in North Carolina, as Mr. Grady indicated, are governed by statute, and that's the same thing that Mr. Stanton said. So the legislature, in its infinite wisdom, said, we're going to create rules about how we deal with appeals from lower boards that make quasi-judicial decisions. How do they go up higher? And the legislature enacted 160D 1402, which is before you. Thereafter, there was questions about, well, what do these words mean? What does standing mean? What do special damages mean? And those are the cases that you've heard reference, which I think you will continue to hear reference. You may hear reference tonight about cases before the Supreme Court of the United States. As I indicated, the Supreme Court of the United States and their rules on standing are completely different than the standing rules for land use law in North Carolina. One of the cases that was cited in your packet is the Committee to Elect Dan Forrest versus Employees Political Action Committee. And for purposes of the record, I'll give the citation. It's 376 NC 558. It's a 2021 case. It was decided by our state Supreme Court. Okay? And around about page 608 in that decision, there's a lot of pages, our Supreme Court said these words. In summary, our courts have recognized the broad authority of the legislature to create causes of action, such as citizen suits and other types of things, even where personal factual injury did not previously exist, in order to advance a public interest. So what that means is the courts, our appellate courts, the judiciary recognizes that our legislature has the ability to enact laws and create causes of action, create pathways for people to make legal challenges. That's what that means. And the court goes on to say, in such cases, the relevant questions are only whether the plaintiff, the person that's bringing the action, has shown a relevant statute confers a cause of action and that the plaintiff satisfies the requirement to bring the action under the statute. There's another important part of this case that says when a person alleges that they've experienced some type of infringement of their rights, either at common law, under a statute, or under a constitution, in any of those bodies of law, the legal inquiry is about standing, which is why we're here tonight. The North Carolina Constitution confers standing to sue in our courts to those who have suffered an infringement of their legal right, because every person has a right to bring their cause of action under our Constitution. Thus, the legislature exercises its power to create a cause of action under a statute, even when a plaintiff has no factual injury and the action is in the public interest, provided the plaintiff has standing to vindicate that right, so long as he's in the class of persons on whom the statute confers a cause of action. That was a mouthful. What that portion of the Danforth case says is you have standing if the legislature says in the law that you have standing. So that points us back to, okay, our judiciary is interpreting what the rules for standing are, and our judiciary has told us in this case that you have standing if you bring an action under a statute, and that statute lays out what the rules for standing are. So in our case, reading these cases together, as Mr. Airy has talked about, Mr. Grady rather, a person has standing under the law, as our courts have told us, if they can check one of the boxes in the governing statute. And the governing statute in this case is North Carolina General Statute 160D 1402. Did I thoroughly confuse you, or have I helped to unpack it a little bit better?
Helps.
Yeah,
Okay.
It definitely has helped.
Okay.
I do have a question, though, if you're...
Yep.
And I don't know if it's which way the question should be addressed, but since we're discussing North Carolina law and there has been some information given to us in reference to Supreme Court law. Has anything from North Carolina ever gone to the Supreme Court that we're aware of in reference to land use?
No, sir. Not in reference to standing in land use to the U.S. Supreme Court. No, sir. All the case law is North Carolina specific for the very reasons the council has stated, but we do have some very on-point North Carolina case law that gives us the rules of the road.
Yeah, thank you. Do we have any additional questions, comments, discussion? Thank you.
Mr. Chairman, if I may, as a housekeeping item, I have a thumb drive that contains everything that's been provided to everybody this week on account of this hearing. I would like to ask that it be admitted into the record if I could give it to your clerk.
Yeah, I would say yes. Do we have any discussion in reference to whether we should or not? Do we need a motion?
No, if the board is willing to receive that, if there's no objections, then it can stand admitted.
Yeah.
No objection? No objection.
Yeah. So let's put on the record that we did accept the flash drive with the information, and it's in Kendrick's possession.
And, I appreciate your hearing us this evening, and we'll, of course, be on standby if you have any questions later on.
Okay. Yeah, thank you. Yeah, Mr. Halton? Yeah, thank you.
Matthew Holton, I live at 302 Avenue A in Riverside. I think that's all I have to, for identifying myself for it.
Yeah, sure. And before we get going, since you brought up Riverside again, could you clarify how far you are from the property?
Oh, I would agree that the estimate is provided by the county.
Yeah, fair enough.
1.2 miles.
Yeah, thank you.
Okay. I don't think I've participated in observation on a lot of different hearings in this space. I don't know that I've ever been to one of these, so if I'm working out a term or using the wrong terminology, I apologize in advance. I did have one clarifying item that I had a question about, and it's related to just the different relationships related to this hearing or standing, and that this is a compartmentalized hearing just for standing, to then go to the next procedural item if it were to proceed. Right? Okay. My question is related to a motion was filed by Craven County to dismiss. Is Craven County representing New Bern in the perception that New Bern is the legal representation of the HPC and the HPC process for which this board oversees the functions and decisions of it? I guess I just want to know how many people I have to convince, or how many people get to kind of ask questions.
Now, Jamie may add some to the answer, I guess, but it's my assumption that we have an appeal to a decision, and the decision was Craven County with the city. And so Craven County, being the original applicant there, has the right to put the application back in, or the appeal to the hearing, or excuse me, appeal to your appeal. And maybe I've said this backwards, but please help me.
Okay, I'll help you. So Craven County represents itself. As I think Mr. Grady indicated when he came to the podium, that Mr. Grady and his firm represents Craven County. The people making the decision tonight are the members of the Board of Adjustment. So as far as the number of people that need to be convinced of a particular position, it would be a majority of the members of the Board of Adjustment.
Did that answer the question?
Kind of, yes, but then my question is, what role does Craven have in presenting material in the standing hearing? I agree that because they are the property owner, if standing was then determined by this board, because the standing is related to the process, not the property, that the appeal is related to the process that took place by the HPC that led to the COA approval, not the COA approval itself, and that the standing is related to the process by HPC, not that the property not the property owner itself being Craven. Did I make it more confusing?
Yes and no. Now Jamie might have.
I think I understand. So ultimately, Craven County is its own entity
Correct.
in this matter.
Correct.
The Board of Adjustment, we're not affiliated with Craven County. This is within our purview. It's in the city limits, so that's why we're hearing the case.
Correct. And I guess my question is, this board, the legal representation for this board is the city because it's an HPC activity.
It's been escalated to a different board from HPC, yes.
Correct. So I guess how does Craven in the standing hearing get to present material counter to determination of standing of the...
That's to do
So
with
I think Jamie's
motion
may
to
be
dismiss.
this might be a good question for Mr. Grady to respond to as to why
This is
he
not the
had.
foundation
Yeah.
of the discussion. I just want to make sure that
No doubt, but I don't think we would be here if there wasn't an HPC decision, and that was City of New Bern. And that's how the process got started. You know, if Craven County hadn't owned the property.
Let's zoom out.
Is that right?
Let's zoom out real quick. So at the HPC, Craven County filed an application for a COA, Certificate of Appropriateness. If you look at your screen and you look at 160D 1402, Craven County had the ability to bring an application because Craven County owns that property. Okay. Now that a challenge has been made to the validity of that COA, for whatever reason, we have to look at who the parties are at the appeal. And this statute tells us who the parties are at the appellate process. So if we look at subsection C, number 1, any person or entity possessing any of the following criteria: an ownership interest in the property that is the subject of the decision being appealed. That would be Craven County. So Craven County is a party to this action, therefore has standing to participate in this hearing. The issue of standing is jurisdictional. It's not just about was the process followed. If a person or entity does not have standing, they do not have the authority to invoke the jurisdiction of the board. So the threshold issue tonight is whether we know that Craven County checks a box about standing because they applied for the COA and got it, and they own the property. At least that's the evidence that's been in the record. The question now is if Mr. Halton has standing or can demonstrate standing. Does that make sense? Did I answer that question?
It does. And then, so yes, I agree that they have standing in the appeal process. I'm not sure about, I guess what I'm asking for clarification on is their ability to influence the board who has to make a determination on my standing, which is related to the City of New Bern process and not related to a relationship with Craven County for my standing determination until if it were to move forward to the actual appeal. The county has standing in the appeal process. I'm not sure that they have an appropriate role in presenting material to this board governed by the city that determines my standing. Did I make it more confusing?
I understand what you're saying. You're basically saying that you're here to see if you make it for the standing part of it.
Correct.
And should Craven County be a part of that when you see it as being separate?
Correct, because the appeal and the standing determination is related to the HPC process, not...
It's related to both.
Totally
So you have to
related.
have standing at the lower board level, and you have to have standing to bring an appeal. So you need standing in both places.
Correct. I agree with you.
In this circumstance, Craven County has filed a motion. Craven County is a party to this appeal.
Yeah.
I think we all agree to that. And as a party, like in any court proceeding, this is quasi-judicial, so it's very similar to going to court. There are two people on either side of that V. You can have State of North Carolina versus John Doe, or you can have Bob Smith versus Jane Doe. In this case, if we were to give it a caption, it would be, if we're identifying parties, Mr. Halton would be a party, and certainly Craven County would be a party. Since Craven County is a party, it has the ability to bring that motion to raise a legal issue for you to decide. In the court process, when someone makes a motion, assuming it's proper, to make the motion. Are they in fact a party? Yes, they are. Did they file it timely? Yes, they did. Is it on its face not ridiculous and germane to the proceedings? Yes. Then that party, the person who makes that motion, then has the ability to offer oral argument or offer case law in support of that position. Likewise, the person on the other side of that motion has the opportunity to make oral argument or present any evidence that they might have in opposition of that motion.
Yes, so, correct. So now my question goes back to the original one. Does Craven represent the position of New Bern in their providing testimony to the determination of my standing, which is the responsibility of New Bern and this board?
No,
Craven
they
County.
filed the
No
motion.
representation of Newland.
Correct. So the representation for the standing portion, not the appeal portion, the standing determination is a city of New Bern function because it's HBC standing, not appeal standing.
It's all city of New Bern. I mean, but that doesn't mean that the original person that owns the property, which comes back to what the law that Jamie just cited, we're looking at it right here on the front. They own the property. They have standing, so they have the right to.
I agree.
So then we're in a circular motion here that I'm having a hard time.
I'm explaining it. I'm not explaining it clearly.
Let me ask you a question. So in your documentation, you mentioned that one of your injuries was having to hire an attorney.
Yes, sir.
Do you have your attorney here?
I do, sir.
Can your attorney, if they're signed up to speak, help muddle through this a little bit easier and explain the process? So are you signed up and sworn?
I am signed up.
So maybe you can help us understand where the challenge is here.
Well, and maybe-
Can you please state your name and address?
Yes, sir. It's Clayton Cheek. My residence is 4507 Berkeley Drive, which is in Trent Woods and not in the city limits, but I am an attorney here with Mr. Halter.
So what we would like from you is to understand how the question of standing is so confusing for one, but potentially not for another. Because I'm assuming you advised him on how to speak. So
Yes, sir.
maybe I'm wrong.
Well, no, yes, sir. I mean, he wanted me here today, maybe a little bit of moral support. Mr. Halton, filed this appeal a while ago. I just recently got involved. I think this is a little bit of maybe an esoteric argument. I think the concern that he's kind of feeling, but it's part of the process, which is just part of the process, is that he's coming before you all and advocating his case. And then within that, the city's attorney is here giving additional advice and guidance. And so I think that is the way the process works, but I think he just wanted some better understanding to make sure he understood who was advising whom. And to a certain extent, I think he felt a little like, there's two different attorneys in two different legal entities that he's battling against, so to speak, whereas there's only one party, Craven County. And that's just part of the process because this is a quasi-judicial board.
Specifically related to the standing determination. There's two separate parties represented in the determination of just the standing, not the appeal. The standing is only determined by the city and this is not
The motion is what has invited them in. So you received this via mail, right? I see on the end of it that you got a copy. Okay. So the motion that they filed is what has invited Craven County into this. Is that correct, Jamie?
The motion that was filed certainly is what sparked the conversation about standing, certainly. From my reading of the law, Craven County was a party to this appeal because it is the owner of the property and the applicant that received the permit that is the subject of this appeal.
I think his question is why is the county here since it's about standing and that it shouldn't, like the motion is about the appeal and the standing is trying to figure out whether or not he has standing or not. So his question is why is the county here speaking when it should just be discussing does he have standing or does he not have standing?
My job is to convince standing to you, not to counter arguments from the property owner. That takes place in the second case.
Respectfully, as a party to a case, you get to advocate at all stages of the proceedings on relevant issues. So if there's an issue as to standing, certainly Mr. Holton gets to make arguments to you all about why he has standing. I can't think of any authority, any case, any statute that says the other party to the case does not get to speak to offer a countering position. To me, that would fly in the face of due process in the 14th Amendment. And I don't know, Mr. Grady is standing. I don't know if he has something to add to the discussion on this issue.
Should we wait for Mr. Grady till the rebuttal since he has the opportunity to speak in rebuttal? Or I don't want to get too confused in here, but
That's fine, Mr. Chairman.
yeah, thank you.
Mr. Chairman and Jamie, the way I look at it is that, let's say that the property owner is John Smith. Would he not have the right to bring to this hearing because he is the owner? I don't think you should think of the owner just in terms of the county owning it, just the fact that a person or entity owns the property and you are appealing the decision by the HPC.
Right, and
So he would have the right, whoever that other person is that owns the property, has the right to speak.
during the actual appeal determination, but not, I don't think, in a way to influence the standing determination. They're two separate elements of the same process.
I look at it that the other party is not influencing me. They are presenting evidence to me so I can make a decision that follows the law.
Okay, and I just needed to make sure that
I agree with
I
that.
highlighted a concern based on kind of what I see. Defining who's who in this hearing, I agree that there is clear standing in the second portion. I think it's not necessarily as clear from this when offering testimony to a body to determine my individual standing.
So you just lost me again. We're making progress. So your statement then was it was clear in the original process or the next process, but it's not so clear here.
Correct, because in the appeal, they are the landowner. This process is a piece of business between myself as the applicant, the determining body as the overseer of the HPC process, and the city, which serves both forms. It is not a Craven County process to determine standing by the board.
Jamie, I'm getting more confused.
They're not making that determination. He's just presenting evidence. It's just like you are. So we actually make that determination whether you're just hearing his stance.
I don't think it may not be appropriate unless determined. So I'm asking, yes, confirm that it's appropriate for an outside entity.
But
He's not an
outside entity. He's the owner.
Correct, but related to determining my standing.
But
the motion.
The motion kind of talks about
Challenges the
the
standing.
Perhaps we're at an impasse, and I think what Mr. Holton is asking for, and it's not unreasonable, is for this board to make a determination if the county has the right as the owner of the property and the permittee that is the subject of these proceedings, if Craven County has the right to participate in this hearing. So,
Mr. Chairman, I move that the county has a right to have a part of this hearing.
So we have a motion.
I second the motion.
And we have a second. Do we have any discussion? So all in favor to the motion that says Craven County is a party and does have the right to discuss?
Aye.
Aye.
Any opposed? Motion carries. So we agree that Craven County attorney does have an opportunity to speak.
Thank you, that's correct.
Okay.
It's great. Government's great, right? You get to participate, and that's
Sure.
That's why I'm here as a private citizen. Everybody gets that opportunity, and so just want to make the process happen, even if I have to nudge it in a very odd and confusing way. Okay.
Sure.
Thank you. I believe everybody received a package outlining the different elements of how I would propose kind of 4 elements related to how I would present that I have unique standing. Related to how the process was conducted. And in this matter, as I stated earlier, it's not necessarily about the property. It is the process that took place by the HPC that then produced the COA determination. So my appeal is related to how the process was conducted to ensure that it was conducted in accordance with the guidelines, rules of procedure of HPC, which has oversight by this body. The part of the reason why this is a unique matter and in related to standing determination is the property that is being discussed, where the decision made about the property is related to a National Historic Registered building. So the process that took place is required to achieve a higher elevated level of decision to authorize demolition of a National Historic Registered building. Therefore, the way that process is conducted, one should be under additional scrutiny because of the level it is required to get that approval, but also because this decision or the appeal related to how the process was conducted appropriately or inappropriately or in accordance with guidelines will now establish a precedent at such a high level that being a member of a unique community directly affected by COA determinations in the future, because I live in a historic district, I am a historic homeowner, that by establishing an erroneous precedence now due to flaws in the process, not the property, that precedent will be open to flaws in the future for when I personally have to apply for COAs, for which I have to do because I'm still in my renovation phase. So as a individual who has to participate in an HPC process, which is defined as a police action, there is an expectation of due process, and that due process is carried out equitably in accordance with the rules for everybody who is within those communities governed by the HPC and their guidelines.
Yes, so what did the HPC do that was inappropriate?
So before I answer that, is that in the appeal process, or I just want to make sure I'm not
Mr. Chair.
muddying waters later.
We need to establish standing first.
Well, I'm asking a question based upon what his statement just was, that there was...
I think it was a little off track.
You think so? Okay, fair enough. If you think it was, fair enough.
I don't, okay. So the 4 elements that are detailed, and I can either just summarize them in a little more detail. In fact, some of what was presented as case law is actually cited in here as the reason why standing exists, because it's a legal process that had an error in it that causes a specific damage to a limited scope of individuals who have to appear before the HPC and may or may not be governed by the same procedures in the future, or a misappropriate application of those same procedures in the future could affect historic property residents by an inappropriate decision based on an error in standing and precedent determined by this matter, the process, not the property. There are 4 there, and I'm happy to go into detail in them. The first one is the injury in fact by personal resources, time, and financial to address this matter, which is a cause of an error in a procedure by a government body that governs rules and regulations and ordinances of the city on their behalf. The second element is the future precedent kind of already addressed the level of precedent that will be established by the process or confirming that the perceived errors in process took place and that the decision and the outcome of those errors is accurate in the future, may cause those same errors to cause damage, or at least not make it clear to which rules or procedures that I, as a future petitioner with a COA for the other projects that I still have to conduct, I don't know which rules or precedents I'm having to file or will be heard against by the COA, because it makes it unclear as to which rules are applied due to the ones that are presented in this case. In the second portion, the third element is the standing by correct procedure and action. Okay. This is related to the comment that in the email that I sent to Alderman Prill, there is a statement in there that says that I determined, the self-determination that I did not have standing. And there's a reason that it's in there, because another member of the general public also participated in that hearing and tried to offer testimony within the same strict guidelines of 100 feet personal damages, the strict adherence of, and he was told he did not have standing. So by self-determination as a regular participant in the HPC process, as an audience member and as a petitioner, it was clear to me by that determination by the board that I would likewise not have standing. However, in going back to the appeal is about the process, not about the property. The entire process had to take place in order, so the board had to complete its entire actions before an appeal about the action could take place. So in place of not having my standing determined, because I witnessed a like member of the community not have standing, and this is on the video, I offered general comments during the end of the meeting, during the hearing, related to an uneasiness or an observation about a misapplication of the standards and the rules in the different cases, specifically this one, based on the information within the staff package, the rules of procedure, and then the final outcome. So there is testimony on the record, on video, to be reviewed. It's at the 3-hour and 30-minute mark within the video, for which I registered, not standing, an observation that there was something that was not accurate with the proceedings as they had taken place that led to the COA determination. I would also offer that there is within the procedures book, there is 2 types of standing that can be offered based off the type of property or project that is being discussed. One is the standard of the 100 feet within the property, you get a notification. That is a general form of business. However, there is a statement within the policies that if a project is deemed to be of such size or scale, I can quote it if I look at it, but is of such a size or impact to the community where many members of the community will be impacted by the outcome, that a special hearing should be voted on, in which case standing would be open to all members of the community, for which then members of the historic community, which have to adhere to these policies in the future, could then offer their own observation and input to the process to the outcome that was obtained. So I think had an appropriate form of standing been voted on by process, by adherence to a documented process, not only myself, but the other member who was there to offer testimony would have had standing if, again, the rules of the process had been applied appropriately due to the size and scope of the project, not the property. And then finally, in relation to the demonstration of unique community affected, the outcome of COA determinations by an erroneous or not necessarily completely aligned process will only affect a small portion of the citizens in the Bern, namely those that live in historic districts or own historic properties for which I am a member of that community. Therefore, it is unique to a small portion, not the general public, And then additionally, as you saw within the documentation, I'm not just a historic homeowner, but have been involved in the historic preservation community of New Bern as a member, as an active participant in the historic events within this community to help preserve, by an appropriate process, the culture and historic nature of this town. I think I got it all.
Okay. Do we have any questions, comments, discussion?
Mr. Chairman? Sorry.
Go ahead, you first.
What I'm hearing is that you are discussing how HPC has their guidelines and how they handle their hearing. As I have been told, as my role on this board is that we have to determine if you have standing to bring an appeal, which means you either have to be the owner, leaseholder, or you're going to buy the property with a written contract. And those are the three things that I had understood we were to look at.
There's also will suffer special damages, which is a number 2. So that's the issue that I believe. The special damages.
Special damages, yeah.
Ashley? Yeah.
My question, you done?
Yeah.
So, Mr. Halton, you had talked about the fact that you feel like this was a large project as opposed to something that would be a project only affecting people within a 100-foot radius. Can you define in your ideal what you believe a large project would be as opposed to something that's in a smaller geographic area, and how would that materially affect a large number of people?
Okay. As I'll use myself as a sort of homeowner, I have to apply for a project, anything that affects the construction or appearance of my home. Okay. Traditionally, these hearings are homeowners within the 2 historic districts. That's appropriate because the immediate area of people being affected is within, I will offer, a small radius of 100 feet. Because it's central, it's local and smaller in physical scale, and the type of projects that are being conducted are not far-reaching. They're normally just within that property or within the surrounding 100-yard property. In this case, because of the physical size of the building, it's an aspect of the New Bern skyline. It is physically present on a corner property visually, as well as the historic aspects of it. But again, that's not necessarily the element of standing identifying. The definition of large project is also ill-defined, but I would offer in this case, by the physical scale of the building, the impact to the physical aspects of the historic district for which it's located, I would offer that that is a large project, for which it would then lead to the question of a vote. So there's still, it's just because it's not a large project, it doesn't automatically open up standing to a wider audience. The HPC still, within their guidelines and procedures, votes to then make it a special hearing if the project is discussed and determined to be a large project.
How would that materially affect, though, a large number of people, this community, for instance?
So, by the process that determines that, because of the size of the building and the project in its nature related to historic value, that it is a nationally registered historic building, and that level is so high to get an approval for demolition, it now makes that same level of approval lowered by errors in the process, that this can be repeated in local neighborhoods by a misapplication of due process of the rules. So the damages would occur based off the high level of established precedents, which will then be repeated or has the opportunity to be repeated inside local historic neighborhoods.
Thank you.
So I remain a little bit confused about the process. And I want to clarify some things because these documents are all going to be online and be a part of record. So the letter that we're reading, it's in the introduction, it starts out as "we, the undersigned," and at the end, it ends with your name on it.
Yes,
So "we" is plural or implies plural, and obviously it's singular. So I'm somewhat confused on how we got from point A to point B and where the injury still comes along through the process. So I'm going to make this a two-part question.
Okay.
So that's the first part. The second part is in reference to the evidence of standing. So the two cases, one, the TransUnion LLC, and the second being the Spokey. So it appears that the words here are taken out of context. You know, that it's not the whole sentence, and I'm curious if a person was to look at the primary holding or just the summary of those cases, if that language was taken out of context, or if you're aware of what that whole case was. Can you elaborate, I guess, is what I'm asking, from the "we"?
So the "we" is an editorial error. "We" is just me.
Okay, thank you.
And it's just me.
And so the injury also is just you?
At this time, it is.
Okay, thank you.
Okay. Now I say at this time because that is related to the special damages only relating to a small cohort of the community for which I am a member.
Fair enough.
Okay.
I understand.
Okay.
So now when we move down to the evidence of standing and we have those two cases, can you elaborate on what those cases are about instead of just having some words that are taken out of context?
Which ones were those? Sir?
Either one. I'd like to hear a little bit more about both.
The
TransUnion versus Ramirez.
Craven. This is where I'm from.
Fair enough.
Okay. The question is about these two as related to the case. And I can give you a layman's answer, but I don't know the kind of what you're.
Yeah, I mean, and I know that online a person can search pretty quickly, and there's actually a docket number, and it comes up pretty quick as far as the summary. And so I did that, and so it appears that some of this is out of context, is why I'm asking the question.
These first two.
So, if I may, not to move away from your question, I think that it was raised earlier that there were some U.S. Supreme Court cases that had been cited, which I think are these cases
Sure.
you're referring to, and that really the cases that probably are most relevant would be the ones in North Carolina, the Court of Appeals, or the North Carolina Supreme Court. And I think that the argument that Mr. Halton is making is that under the policies and rules and procedure of the HBC, there are some definitions and reasonings behind standing. And clearly someone who is a property owner adjacent or nearby does have that standing. There is language in those rules and procedures that testimony and evidence from a property owner beyond 100 feet may be allowed if, and there are several things. One, the presenter has competent material and substantial information to present that can be directly and specifically related to the guidelines. The guidelines also go on to discuss a typical COA hearing versus a public hearing. And his argument, I believe, is that a public hearing, was not held. Now, the guidelines do say that it may be called, so it's not something where it says must, but for large projects that may materially affect a large number of property owners beyond 100 feet of the project. Again, information presented by a party must be competent, material, and substantial information that can be directly and specifically related to the guidelines. I think some of the additional concern, and this gets into some arguments that aren't really related to standing, are whether the procedure was correctly followed. again, some of in the policies and guidelines, which are here, they may be different than some of the state statutes, et cetera, but talk about what is needed for a quorum, and that 5 members of the HPC are required to hold a hearing. And my understanding was that this hearing, there were 5, but 1 recused himself, so that got to 4. And so part of the question is whether that procedure was properly followed. Now, regarding standing, we can't really get there until we talk about standing. However, if that procedure was not followed correctly, I think really what his concern is just making sure that we don't set a precedent here where something was not done correctly that then may violate the due process of the community or maybe another party that would have standing. And in addition, as someone who comes, and I'll back up and say, if due process were to be violated, I think that would be similar to a statute or a cause of action or a due process issue where he would then have standing, because he could say that his due process or potential due process has been violated, and as a result, he would have standing. The cases stipulate that, again, when a statute is an issue, a cause of action, or a due process issue, that you would have standing. And there is a North Carolina Supreme Court case that addresses that issue. It's the Society for the Historic Preservation of the 26th NC Troops, Inc. versus the City of Asheville, and that was a March 2024 case. And I think, again, Mr. Halton's real point is just making sure that all of those procedures have been followed. In addition, his concern being that he's going to be coming back before the HPC. He's been there before. He'll have to come back several times, and I think just wants to make sure that the procedure is correct, and that would bring. But the question is, it's sort of a chicken before the egg, because we can't really get too much into that. That would be an issue on the appeal, not an issue on the standing. But I think there's an argument to say if that had been done, that there might be a violation of due process, which would give him standing.
So let's just clarify just some of the nomenclature that's been used. The Historic Preservation Commission has guidelines, aka design standards, that are the architectural and other criteria that they use to determine whether modifications are appropriate. So that's one document. There is a separate document called the HPC Rules and Procedures. The Rules and Procedures is the document that I think Mr. Cheek was quoting when he was talking about how the HPC determines standing and the concept of a public hearing. And I think Mr. Cheek, just for purposes of the record, was referring to the HPC Rules and Procedures, specifically page 15, which sets out property owners, which tracks with the statute 160D 1402, people who are materially affected by the COA, which arguably would go to subsection 2, any person who would suffer special damages, any associations, which would then go to subsection 3 of the statute that's on your screen. So the HPC's criteria for standing largely tracks the statute. What is a little bit different than the statute that the HPC permits is the public hearing that you've heard Mr. Cheek and Mr. Halton talk about. And the section says this: a public hearing may be called for large projects that materially affect a large number of property owners beyond 100 feet of the project. There's nothing in the Rules of Procedure that requires the HPC to conduct such a hearing. So I just want to make sure that we're talking, when we're thinking about these documents that the HPC has, we're referencing the right documents and having those page numbers in the record.
Could you read the portion about the vote?
The next paragraph says that if the HPC does conduct a public hearing, it must vote to conduct a public hearing on a COA. There must be proper notification that the HPC is considering a public hearing on the COA application, and a public hearing can be held at the next regular meeting or at a specially called meeting.
And just to clarify, that does not create standing if the guidelines were not adhered to by the HPC, is that correct?
If the HPC opened up, if the HPC voted to do a public hearing, it would invite people who are able to demonstrate that they would be impacted by the project beyond 100 feet to offer competent material substantial evidence.
But in this case, that's not the case.
There was no vote. I don't think your record shows that there was a vote to conduct a public hearing, nor was a public hearing had consistent with the rules of procedure.
And that's one of the elements presented, have that determination been made that this is a large project, standing would have been allowed as a larger project.
Right, but we're here to determine your standing now.
Correct.
And so that's kind of retroactive in this regard.
Yeah. But again, in the guidelines, there is understanding, the definition that a property owner beyond 100 feet may be allowed and considered to have standing if, again, the presenter has competent material and substantial information to present that can be directly and specifically related to the guidelines. And I think that's what his point is.
Right, but I think we're trying to determine standing for the appeal right now.
Yes.
Right, but in the definition of standing, which I'm just pointing out that in the guidelines, in addition to the statute.
HPC guidelines, right?
Yes, sir.
Okay,
Yes, sir.
but we're not at an
does
HPC
state-
hearing.
That's correct. However, we're talking about standing in front of the HPC as well as.
Yes, at the time, but the HPC has heard this already, so we're here now on Board of Adjustment. So we're talking about the criteria on the screen.
I understand. And again, part of his issue is the procedure, which would be something that would obviously be very relevant on an appeal. And this is where it's a little chicken before the egg.
Right, but we can't hear the appeal without the standing.
There is a possibility that some due process may have been violated in the process of the HBC.
Okay.
And the point is that if that were the case law would give standing to somebody to bring an appeal.
So on that issue of process, again, we're referring to the HPC rules of procedure. The section on standing that Mr. Cheek is referring to says testimony and evidence from a property owner beyond 100 feet may be allowed if, and there are 3 bullet points, again on page 15. It is not a repetition or duplication of testimony and evidence that has already been presented. The presenter has competent material and substantial information to present that can be directly and specifically related to the guidelines. And the 3rd bullet, the presenter can demonstrate that they may be materially affected by the proposed change. So those are the rules governing standing if you live at a greater proximity at the HPC. And as I think it's been discussed here tonight, Mr. Halton exercised his right not to attempt to provide information to the HPC at that level. So now, whether he had standing at HPC or not, it's somewhat of a non-starter because there was no evidence that he attempted to offer in that hearing. As Mr. Thompson has indicated, the question before this board tonight is, does he have standing to invoke the jurisdiction of the Board of Adjustment to challenge the issuance of the COA? Can he demonstrate that he has standing under the laws of North Carolina?
And I think the way that, again, you could establish that standing would be if there was an issue of due process. And this case, actually, the committee to elect Dan Forrest, I think, also cites that, and I think actually Ms. Bullock read this, but when a person alleges the infringement of a legal right arising under a cause of action at common law, we don't have that. A statute, arguably we don't have that. Or the North Carolina Constitution, which we may have if there was a due process violation, that legal injury itself gives rise to standing. So that is his argument, is that as a member of the historic area, and if the procedure was not properly followed, then we have an issue of due process under the Constitution, which then gives rise to an injury that gives legal standing.
Okay, so I've got 2 questions for Jamie, if I can interrupt for a second. So the first one, I know there was a due process question that we kind of went over about the 5 versus 4, that the meeting started with 5 and we ended up with 4. So can you explain a little bit as far as that process?
That is an issue for the appeal on the merits.
On the merit, okay. And then the second question I have actually comes back similar to what we've discussed already. The Political Action Committee 2021, how does that affect land use?
So that's a good question. So the statute that is the subject of the case, and I'm sure Mr. Grady might have an opinion on this as well, talks about standing as it relates to a specific statute, the disclosure statute for political action stuff. There's a relevant legal doctrine, because this does unpack standing when somebody is bringing a cause of action pursuant to a statute. And I would submit that the appellate process in land use is codified by statute. It's in Chapter 160D. So since we're using a statutory process to perfect a cause of action, that being an appeal, we have to use that statutory process to determine whether standing exists. So the portion of the case that I think Mr. Cheek was referring to, and I'll read to the end of the paragraph just for the sake of clarity. When the legislature exercises its power to create a cause of action under a statute, even where a plaintiff has no factual injury and may be acting in the public interest, the plaintiff has standing to vindicate that legal right so long as he is in the class of persons on whom the statute confers a cause of action. So a person has standing under the case that Mr. Halton has cited if they have standing under the statute, which directs us back to 160D 1402.
And I would say that is correct, or the North Carolina Constitution, which is the due process argument.
Yes, sir.
Yeah, I was thinking most of the main thing is what he was saying. But I feel like he's talking about is that, but he don't realize that HPC have the option of having a public notice or not. So they took the option of not having it. And so when you were there, you wanted to say something, but since they didn't have a public notice or wanted anybody to speak, you didn't get a chance to speak because it was, I guess it would feel like you didn't have any standing at that time.
Based on the determination that they had made to a similar party, I understand, correct. However, on the record, during the proceedings, I did publicly address the board in session that there were misapplications or not like application based on my observations of dozens of HPC hearings related to the material presented to the board, the guidelines and procedural elements, not the building itself, but the procedural and guidelines misapplications. I did register that concern. It's on 3 hours.
It's there. I unfortunately watched the whole thing, so it's there. Yes, sir.
Can I ask a question?
Yes, sure. We can
So
all.
this is probably more directed to you, Jamie. Okay. Just so I'm understanding this, so Mr. Is it Halton?
Yes, ma'am.
You're a county resident.
I am.
So if the property is owned by the county, which would be owned by the taxpayers, would that make it an ownership interest?
No, ma'am. Craven County is its own separate legal entity, and Craven County is actually the Craven County Board of Commissioners, not the taxpayers at large. Unless Mr. Grady can define his client himself, I guess. I don't mean to steal his thunder.
We can add that to the list on the rebuttal, I guess, right?
But
If
you want him to answer the question, I don't know if you want
Can we
to
do
hold it
that?
or if you like.
For the record, he did say he agrees with counsel.
Okay. Thank you. Do we have any additional questions?
And then I just want to ask this, what I asked earlier. I know he was speaking about a quorum, say to start off with a quorum, but someone left. But don't it still stand, even if you have a quorum and somebody leave, won't it still stand?
That is an issue for a hearing on the merits. So we're not there yet. We've got to figure out if Mr. Halton has the right to invoke your jurisdiction.
Okay.
Does it look like you had questions?
They have not seen the appeal, is that correct?
They have received your notice of appeal, yes, sir.
Okay, the document,
Yes, sir.
okay.
I was going to ask Mr. Halton if you would very succinctly, we put a lot of words to this, but very succinctly define what your special damages entail.
My special damages are, I am required to participate in the COA process as a special category of homeowners inside the historic district. Therefore, special rules apply to me as a homeowner in that district. And if those rules are applied inappropriately, that is a special damage only to me in a miscarriage or misappropriate application due process.
Does that help?
No.
Yes, I think I'm confused somewhat in the same sense. Because if it's as a group, technically it may not be special. When I think of it as special, it's maybe more as an individual, and Jamie helped me if I'm going down the wrong road with this. So that's where I'm kind of challenged, and that's kind of why I asked the question originally about the injury or damage, from a specific standpoint. And we get back into the same circle about that it's a group situation again, and I understand that, which is also why I wanted you to clarify the we versus singular on the whole process, since there was a lot of other verbiage in it. So I'm going to have to defer somewhat to Jamie again. How do we get from discussion as a group, as a resident, to a singular special damage?
Well, that's a fine question, and I'm not sure how you bridge that gap. What I'm hearing Mr. Halton say is he is anticipating that he might have harm in the future if he submits an application to the HPC for a COA and the processes are not applied to him fairly, then he may have some special damage in the future. To that, I would say, in the event that that happened, he would have certainly a cause of action as an applicant to appeal a decision to perfect his right as a property owner and an applicant. But in this context, I'm not sure how you bridge that gap. I don't know if at this time, if you have any additional questions for Mr. Halton. I don't know if the board would like any rebuttal from the county, but perhaps that might add to our conversation.
I would agree with you. And the example I'll use to kind of use what you explained very well is Riverside. There is a line where it's historic district on one side and not historic district on the other side. There is no approval process for exterior construction or changes within the same neighborhood. However, because of where the boundaries are, I have to apply to this process. I know I will have to submit COAs based off of the amount of work to restore the home that's still required. So there is a known future activity to take place for which there is a legal process that takes place for which there is an expectation of equal application of the procedures, guidelines, and due process. That unknown of an infirm determination by the rules that govern that is the damage. I don't have a standard of due process that will be established by this because the procedures are counter to the guidelines and processes in this matter.
Yes, I get it. I'm curious how much future we are allowed to think about in the process, as opposed to today.
Well, all members of historic neighborhoods are required to submit COAs for exterior work, so it is a known activity that has to take place in accordance with.
But
So
we
I think
don't.
that
But we
covers the
don't.
issue. It's not special.
Yeah. We don't know what the future decisions would be.
But it would be based off of, it's a legal process based on erroneous procedural standards set in this matter because the process was not, again, this is about the process not being conducted correctly that resulted in something that will establish precedents that will apply to me in the future, specifically as a historic home.
But just you.
No, all.
So I think that takes out the special to the damages.
Only historic homeowners are required to submit COAs, and only historic homeowners are subject to HPC rules and guidelines. So there is a quantifiable community that only this type of procedure and process applies to. and I'll offer that that is a defined special community.
And you're here on representation on behalf of the entire community or yourself?
I am representing myself as a harmed member of that special community.
Understood. Thank you.
So do we have any additional questions? Thank you.
I'm sorry about your hard.
Hey, that's what we're here for.
Thank you, and that's what I appreciate. I would regret not doing something or doing something and having.
We appreciate the discussion, and I hope the folks that do look at this in the future will learn from it also. So it's all part of the process.
Yes, sir.
Thank you. Mr. Grady, you have an opportunity for rebuttal.
Mr. Chairman, board members, thank you. I have a lot to say. I'll try to distill it. Much has been made of due process in the appellant's arguments, and what happened during the COA hearing for the county, how that may or may not impact his future case and other similarly situated property owners. He has an outlet for that. If he applies for a COA and the rules are not followed in his case, he can appeal it to this board. And if he doesn't like that decision, he can appeal it to Superior Court. So can every other property owner in the historic district. Speaking of due process rights, let's talk about my client's due process rights. My client's a property owner. My client worked with the city of New Bern starting last spring, April or May. We attended numerous technical review meetings. We participated in numerous quasi-judicial proceedings. We did what the city asked us to do, and we got our approval on the very last day that an appeal could be filed. A stranger to this case filed an appeal. He had not participated in anything up to that date. I want you to think about that for a minute. Somebody from Havelock rolls in and files an appeal of the appellant's next COA without having participated. There's a word for that under the law, and it's called waiver. Even if you have the right to participate, when you do not, you have waived your right. My client's due process rights are just as important as everybody else's due process rights in this case. I want to go back to the essence of the county's position in this, and the case is very simple for three reasons. One, we've got an admission on the record that the appellant, Mr. Houghton, does not have standing. He has admitted that in an email. That really ends the case. That makes the case simple. This is not a hard case. You can stop right there. Two, he lives over a mile away from the Shriners building. The North Carolina cases are crystal clear on this point. You've got to have close proximity to have standing. Third and finally, you've got to have economic or pecuniary damages to your property to join a case like this. We've started to get into the subject matter of the appeal this evening. We've gone a little astray from the topic of standing, which is fine. This is quasi-judicial. It's not strictly judicial. What you have not heard this evening is one word about how the appellant's property is going to be damaged by the demolition of that building around the corner. Not one word. The cases require that type of damage. What you have heard, and I think it's the note the appellant basically ended on, was I'm a member of a class of people that may or may not have been harmed by this decision because I may have to apply for a COA in the future. I wasn't specifically damaged, but this group of people may have been damaged. And let me cite for you a case that goes by the name of Cherry v. Wisner. It's a case that came out of Raleigh, out of Wake County, and I'm going to quote for you on that point. It was actually an HPC case, and you're in the historic neighborhood in Raleigh, and the property owner wants to build a modern structure. that's going to stick out like the proverbial sore thumb, right? The neighbor across the street sued. It went through the HPC process, the Board of Adjustment process. It went through Superior Court, and it went to the Court of Appeals. And the neighbor's contention was it's going to ruin the neighborhood. It's basically what she said. It's going to destroy the neighborhood. And here's what the court had to say about that, if I can get to my place. But these allegations do not demonstrate special damages distinct to the respondent, other than the view from her front porch. Rather, respondent alleges a generalized damage to the overall neighborhood, reduced property values, and impaired enjoyment of the neighborhood. The mere fact that respondent's home is directly across the street from the house at issue does not constitute special damages. Mr. Chairman and board members, we've heard a lot tonight, but we have not heard anything that would give the appellant standing to prosecute this appeal. Any questions for me?
Do we have any questions?
Thank you.
Thank you. So we do have the opportunity to ask for additional rebuttal, and I'll also read through the review process so everybody has an opportunity to think, or we can entertain a motion. So we have opportunities here on how to move forward. And I think there were 5 questions that are on the instructions of filing. Is that okay if I read through?
Since we're at the crossroads of just standing, perhaps we should focus our inquiry at this point of your deliberation on standing before we get to the merits. Yes, sir.
Okay. Thank you. So do we have any additional questions on standing to either party that we should ask them to come forward and continue on, or do we?
I'm not really clear on what your claim is for the special damages besides the procedural. Am I correct on that? That it was procedural that's
correct. So my claim is not about the decision. That may still take place. My appeal is related to the process that led to that decision being flawed, not the decision itself. It may still happen. I just need the process, the due process as a member to be correct in this case, because it'll serve as a standard to me as a district homeowner in the future. So correct. It's not the outcome, it's the process that led to that outcome has flaws in it.
So I think the question still remains before us, though, is in reference to standing. And so in a due process, that's why you're here. You filed the appeal, and we have to question the standing before it moves forward to where we can hear the appeal in general. Because if the group decides there's no standing, then we don't hear the appeal. If we choose that there is standing, then we do hear the appeal at the next meeting. So I think that's the challenge. I'm assuming that's why Jamie asked me not to go through the instruction for filing, and because we are standing and not from the appeal process. So do we have any additional questions for anybody, or can we entertain a motion?
If there are no additional questions, and I don't know to what extent you all want to deliberate amongst yourselves, but in making a determination tonight, you all will need to vocalize or articulate the reason for your motion. So if you find that Mr. Halton has standing, you will need to articulate what his standing is. If you find that Mr. Halton does not have standing, you will need to articulate the basis for which you find that he does not have standing.
And would it be a good time to mention again the 3 characteristics that tend to offer standing?
You all will need to decide which rules you think apply to standing based on the evidence that has been, the arguments that have been made tonight. There's a statute on the screen. You've heard about the cases. The general arc of these cases that have been presented tonight is there has to be some individualized damage to that person that's bringing the appeal. So if that's the case, if we all agree that the rules require that a person either have a property interest or some type of damage, then those are our rules. If we agree on the rules, then we apply our facts to the rules. Are you satisfied tonight that Mr. Halton has demonstrated that he has some type of property interest that is related to the subject of this appeal? If not, then we go on to the next criteria. Are we satisfied that Mr. Halton has demonstrated tonight or in the documentation that you've had to review that he has some type of special damage that would trigger standing? Is he representing a class of people that are recognized under the statute or in the cases that would have standing? You would need to go through that analysis, and that may lead you to your ultimate conclusion.
So Jamie, are you asking us to make, I can make a motion for 1, 2, 3, and 4, or do I have to make a motion for each individual one?
You don't have to make a motion for each individual one. If you find that Mr. Halton has standing because of X, then that can be your motion. If you find that Mr. Halton does not have standing because of X, then that would be your motion.
Sure. I mean, if you'd like to make a motion, we can.
Mr. Chairman, I move that Mr. Holman does not have standing based on number 1, which states any person possessing any of the following criteria as ownership interest, B, an option or contract to purchase the property, or C, an appellate before the decision-making board whose decision is being appealed. I move that those criteria.
Okay, so we have a motion, and it's in reference to the GS 160D-1402C, in reference to the standing under number 1, that any person possessing any of the following, and you're saying that they don't, in reference to?
To section 1.
So do we have any discussion or a second?
You need a second.
Second.
So we have a motion and a second. Do we have any discussion? Is it time to take a vote? Should we do a roll call? Well, I think we're past the discussion right now. But
it's related to the act, to how many of these elements have to be met to determine standing. So
I think we're past the discussion. I think we only.
There's a motion and a second on the table. This may be one of many motions that you entertain tonight.
Okay. So we have a motion and a second. Do we do
I'd
a
like
roll
to
call?
make a motion. Can I make a motion with a motion already on the floor or no?
No, we got
Okay.
one motion and a second on the floor, so we need to deal with the motion that's pending.
Do you have a second?
We do.
We do.
Okay.
Does everyone understand the motion that's on the table? Okay. Do you want a voice vote or would you like a roll call, Mr.
What would
Chairman?
y'all's preference be?
Roll call.
Roll call is fine, yeah.
Yes, sir, Mr. Chairman. So, Board Member Sandra Gray. What's that? I'm sorry, I missed it.
You asked me, do I agree with it?
Do you agree with
Yes,
the
Yes, I agree with the motion.
Vice Chairman Eric Thompson.
No.
Board Member Kathleen Marty.
Aye.
Chairman Tim Tabet.
Aye.
And Board Member Leslie Allen.
I disagree.
Board Member Ashley Howe.
I disagree.
And Board Member Barbara Sampson.
I disagree.
motion fails?
And
So the motion failed.
Yes, sir, Mr. Chairman.
So, Eric, you have a motion.
I'd like to make a motion that we find that Mr. Halton does not have standing based on Government Statute 160D-1402C, finding that we were unable to find standing within criteria subsection C1, A, B, and C. We were unable to find the subcriteria 2 either, that any other person who will suffer special damages as a result of the decision is being appealed. 3, that he is not an incorporated or unincorporated association. And 4, he is not a local government whose decision-making board has made a decision that the governing board believes improperly grants a variance.
Okay, so we have a motion, and it basically now becomes all of GS 160D-1402C in reference to standing.
Second.
So So we have a motion and a second. Do we have any discussion? Let's go with another roll call.
Yes, sir, Mr. Chairman. And Board Member Sandra Gray.
I agree.
Vice Chairman Eric Thompson.
Yes.
Board Member Kathleen Marty.
Aye.
Chairman Tim Tabak.
Aye.
Board Member Leslie Allen.
I agree.
Board Member Ashley Howe.
I agree.
And Board Member Barbara Sampson.
I agree.
And Mr. Chairman, it was unanimous.
So motion carried. So the decision has been that we don't have standing on the appeal. Do we have any additional?
If there's no standing, then it may be appropriate to grant the county's motion.
So do we have any discussion before we go there in reference to the appeal motion that the county filed? And so this is State of North Carolina, Craven County before the City Board of Adjustment. Is there a number on this, Jamie?
I think it's case number BRDADJ-003074-2025.
Okay.
That's correct.
So that's the same numbers we have for the, okay, we're good. So that's our discussion to move forward. And if there isn't any discussion, do we have a motion?
I make a motion that we accept the motion to dismiss the appeal.
I second that motion.
So we have a motion and a second.
And just to be clear, is your motion to grant the county's motion to dismiss for lack of standing?
That's
Yes.
correct.
Is that your second, Ms. Allen?
Yes.
Okay.
Do we have any discussion? Can we do another roll call?
Yes, sir. Board Member Sandra Gray.
Aye.
Vice Chairman Eric Thompson.
Yes.
Board Member Kathleen Marty.
Aye.
Chairman Tim Tabak.
Aye.
Board Member Leslie Allen.
Aye.
Board Member Ashley Howe.
Aye.
And Board Member Barbara Sampson.
Aye.
And
So-
Mr. Chairman, the motion was unanimous.
Okay, thank you. So motion carries. Do we have a motion to adjourn?
Second.
So moved.
We have a motion and a second. All in favor?
Aye.
Aye.
Motion carries.